Hello my dear students, I am Professor Manasi Patil from JK Shah classes and I am here with your very favorite chapter, Interpretation of Statutes. Now you will be like, ma'am, you are also teasing us. It's our favorite chapter, really. Actually, na bacha, interpretation of statutes, it's very simple when it comes to understanding. But of course, it is little difficult when it comes to writing because you know exactly what is literal construction, reasonable, proviso, saving clause, etc. You know all of this, but just the problem which you face is the writing. So, bacha, one tip for you. Please try to put as many Latin terms as possible and legal terms possible. So instead of writing statute, you can use the term written will of legislature, something like that. But this you will be able to do, bacha, only if you read it more and more times and you do the ample amount of writing practice. See, interpretation of statutes, now there are hot favorite questions of institute. Like for example, Hayden's rule, proviso, preamble, then I can say saving clause, explanation. They keep on asking you loads and loads of questions on this. So if you see in our textbook also we have given the exercise, the questions. If you see there are some questions which keep on coming. If not all, at least try to practice them, bacha. Like for example, write what is proviso. Now you know what is proviso in your heart. You will be able to explain your friend. But when it comes to writing for 2 marks, 3 marks, 4 marks, you get confused. So the only solution is the writing practice. Okay, I know Latin terms are little irritating for you to just remember and write. But try to remember them as Harry Potter spells, you will definitely remember. As in, we don't have a choice, we have to find some way or the other to remember them. In fact, in CA Foundation also, bacha, you had done Nemo that chord non-habit. First time when you read it, you found it very unusual, you found it very weird, ki what this is. But over a period of time, you got used to it. You had Ubrame Fedi, again you got used to it. Same case here also, you will be getting used to it, but just do not start this with a negative note. 100% you will be able to do it. Just do writing practice of at least 4 to 5 questions. Okay, so now interpretation of statute, how important this chapter is. The weightage is around 7 to 8 marks or maybe little more. Now, if you see the past analysis of the papers where the MCQs have started, they have asked questions of approximately 6 to 7 marks and maybe 2-3 marks MCQs. But it's a small chapter which is getting you at least 8 to 9 marks. It is good. It is totally worth it. You might love Indian Contract Act, but it's big. You might love your Companies Act, but definitely it's big. But interpretation of statutes, General Clauses Act, they are small, but still they will be getting you good marks. And you know the importance of 1 mark, bachas, right? Yes, so with this note, with a positive note, let us start up with your interpretation of statutes. What do you mean by the term interpretation? Understanding. What do you mean by the term statute? Law. So we are going to study how to understand the law. Now, why this particular chapter they have introduced in your curriculum or why it is important in practical life? Bacha, in our country, law is made by someone else, executed by someone else, and it is read and decision is given by someone else. So, it is the parliament who makes the laws. So, they are known as legislative authority. It is the government which executes those laws. They are having executive authority, and it is the court who is going to listen to the parties and give the final judgment. So it is the court who is going to read the law and then say you are right or you are right and accordingly give the judgment. So if you see, bacha, law is made by parliament but it is actually read by the court and the judgment is given by the court. Now it is very possible there might be some misunderstandings between both. But we live in the same house, husband, wife, mother and child, then brother and sisters, grandparents. We live in the same house, we know each other from all these years, we are so close. but still misunderstandings can definitely happen between us. So these people are strangers. Parliament and court, the judge does not know who has made the law, and the lawmaker does not know who is going to actually read and execute and then finally give the judgments. So definitely there can be misunderstandings. So we are here. This will stop you from misunderstanding any law. See, what happens is there can be some laws which are very outdated. Like for example, Indian Contract Act is very outdated, and it's been a long time since they have amended it. So in practical life, do we follow the old laws, or do we update it, or do we assume something else and then apply it, or what is to be done? Or there can be many drafting errors. That poor fellow, the draftsman, instead of writing shall, he wrote may. Instead of writing may, he wrote shall. So your interpretation will accordingly change. So in this particular chapter, we are going to study the rules of interpretation, where they'll give you standard rules. Okay, for reading this law, you are supposed to apply these rules, full stop. See, just as in accounting standards, you have accounting standards which are like standards. You have to follow this only for accounting. Similarly, you had standards on auditing. You have to follow this only for auditing. Now, these you can call them as standards of law. That means you are going to follow this for reading and applying the law. Yeah? So, interpretation of statutes. Let's see. Yes. Meaning of statute, it is written will of legislature. But we Indians are very simple people. We use the term law. In fact, in our constitution also we use the term law. We don't use the term statute. But those Britishers, they use the word statute, whatever. So here they have given you interpretation of statutes. Simple words, written will of legislature. Legislature means parliament. Parliament writes this. Parliament writes this. Therefore, it is written will of legislature. Okay. Then, what is interpretation? As I told you, understanding the law. Interpretation is understanding the law. And why is the interpretation so important? The words are confusing, the environment has changed, but the law has sadly not changed. Then the words are complex, the laws are complex. Ask us about it, we know how complex laws are. And sometimes, the parliament does not cover a particular area. They forget, or maybe it is missed out, whatever it is. Or drafting errors, as I told you, shall, may. Or in case incomplete rules are there. So in this particular case, if the rules are incomplete, you will be applying the rules of interpretation to understand those incomplete acts or rules. Yeah, all this is fine. Document we shall see after we are done with the rules and all, after the whole chapter gets over. Let's talk about the rules of interpretation. Bacha, there are two rules. First you have primary and then secondary. Primary you have to apply first. If you are not getting proper conclusion, you can apply secondary. First one, literal construction. Literal construction means reading it as it is. We use the term literally it has happened. Literally. Literally means literal, as in exactly whatever has happened, you narrated it. So literal construction means reading it as it is, understanding it as it is, applying grammar, applying technical rules or technical meanings or trade meanings, grammar rules, and then interpreting it. This is nothing but literal construction. Now, what exactly is this literal construction? If I take an example, I have actually downloaded Companies Act, Bare Act, Indian Contract Act, Bare Act, so that you understand how do we apply these rules. Okay, so see, in your Indian Contract Act, I am sure you remember there's section 26, agreement and restraint of marriage is void. So if you read it, every agreement and restraint of marriage of any person other than minor is void. What did you understand? That you cannot stop anyone from getting married, but of course you can stop minors from getting married. So bacha, here you applied grammar, normal English grammar rules. Then agreement. Agreement means you will not take dictionary meaning. Agreement means whatever is given in Indian Contract Act. That means you gave the technical meaning. Restraint means stopping, dictionary meaning. Marriage is your normal meaning, getting married. Again, minor normal meaning. Void, you gave technical meaning, that is not enforceable by law, right? So bacha, you read it as it is, you understood it as it is, and you applied it as it is. This is literal construction. So literal construction means you are giving grammar meaning, ordinary meaning, technical meaning, trade meaning, and so on. Now there is one Latin term for this, absoluta, sententia, expositio, non-indicate. Yes, it simply means give simple meaning. That's quite an irony. See, I am telling you in very simple way. I am not telling you exact word meaning of absoluta, sententia. Simple words, it means give simple meaning. Read it as it is, interpret it as it is. But bacha, sometimes no, literal construction does not work. Because when you try to read something literally, some absurd meaning comes. So you have to reasonably interpret it. Give logic, apply logic, and then accordingly draw a conclusion. If I take an example, in Indian Contract Act, you have a term, surety steps into the shoes of creditor. Which here, if you go literally, it means he will go into the shoes, which is highly weird and stupid. So which here literal construction won't work. You will be applying reasonable construction. So reasonable construction you will apply when the literal construction has failed. When you see the words, yes, prima facie it appears to be clear. Prima facie means first impression. But on a close scrutiny you come to know that there is something wrong. So when narrow interpretation fails to achieve the purpose, you will be applying reasonable construction and give the sensible meaning. Example, another example, let's say I'm very upset, I'm almost on the verge of crying. If my best friend comes to me and asks me, what happened to you, Mansi, are you okay? I tell her, I'm fine, just go. If she takes it literally, bacha, she will go. But what did she do? She sat next to me and she asked me, what happened, Mansi? Who told you what? Tell me what is wrong with you. So now I start crying, I am howling, I am irritated, and then I narrate everything to her. That means, bacha, here she did not apply literal construction. She applied common sense. She sat next to me and asked me further. So this is reasonable construction. Yeah. Then you have Hayden's rule, important from exam point of view. Hayden's rule or mischief rule or beneficial construction. What does this mean? See, I'll tell you, in India, there are so many superstitions. Like other day someone told me that you cannot sweep floors in the night. So if you sweep floors in the night, money will also go out. I'm like, really? Does that mean Tatas, Ambanis, Birlas, they don't sweep their floors in the night? They too have loads of money. So if I sweep, the money will go. See, in this case, bacha, why this rule was made? This rule that you should not be sweeping floors in the night was made somewhere in 1500s or even earlier than that. See, because what used to happen at that time, there was no electricity and very less people could afford those fire lanterns, right? So if a poor person who does not have a lantern, if he is sweeping floor in the night, in the dark, so if there is any coin or earring or nose pin, if that is there, that will also go out. Therefore, they made this rule. But now, this rule has no relevance because now we have ample amount of light, everyone has electricity, you have tube lights. So this rule doesn't make sense, but it definitely made sense at that time. Another example. This is the very common in Indian households specifically, that you must have heard that people saying that you should not give scissors or knife to another person directly in his hand, otherwise you both will start fighting. So does that mean I'm not supposed to give it to my husband? Anyways, we both fight. What's the big deal? So me not giving him scissor or not giving him knife, that does not mean we both are gonna stop fighting. So in that particular case, bacha, why this rule was made? Because if you give the knife in the person's hand, he might get hurt. So it is always preferable to keep the knife or the scissors down, and he will take it as per his convenience. That means in this particular case, bacha, yes, this rule still has some relevance. Of course, the reason is quite weird, or the consequences are quite weird, that you will start fighting, but this is the actual reason which is right now also existent. Therefore, this rule has some kind of relevance. So, bacha, what Hayden's rule says? Hayden's rule is telling you when you feel some particular rule is very weird, you just see when this rule was made, why the rule was made, what happened before, and they want to stop what, and they made this rule, etc., etc. So you have to consider all of this. Another example, bacha, we have multiple meanings of the same word. Now in India, Xerox means photocopies, but actually Xerox is the name of a company. So now if some poor draftsman, he just wrote in law, obtain Xerox copies. So literally it would mean obtain company copies. So a mischief is getting created, a weird or absurdity is getting created. So they are saying suppress the mischief and advance the remedy. That means you remove this mischief and you give the appropriate solution. So how will you remove the mischief? Simple. But here the word Xerox will not be treated as a company. Here the word Xerox will be treated as photocopies. So you have applied Hayden's rule. So Hayden's rule is to be applied when the words are confusing and capable of more than one meanings. Literal interpretation defeats the object. So you give the extended meaning to it, and you consider 4 things while applying this rule. And these 4 things are very important from exam point of view. So first, what was the law before? What is the mischief which that law did not provide, or they just missed it? Or what is the remedy, that is the solution which the law has provided? What is the reason for this solution, etc., etc. So you see this background and accordingly you apply it. So suppress the mischief and advance the remedy. So this was your Hayden's rule or mischief rule. Now harmonious construction, bacha. Harmony means peace. You follow your way, I will follow my way. Do not interfere in my life, I will not interfere in your life. Okay, let us live peacefully here, harmoniously. So here harmonious construction means peace. So what happens is sometimes, multiple laws are applied. So you have to first avoid any clash and give effect to all. But sometimes if you are unable to give effect, you have to follow that law which is more specific, or that law which has come later in time. For example, HDFC is a bank. So it has Banking Regulation Act applicable, Companies Act applicable, plus if it's listed then SEBI. So multiple laws are applicable. First you have to give respect to all laws. No law is superior to other law. So all laws are same. So you have to give respect to all and avoid any clashes, give effect to all. But due to some reason, let's say if there is some contradiction between 2 laws, then you follow that law which is more specific. So in HDFC Bank, if there is a contradiction between Banking Regulation Act and Companies Act, you will be following Banking Regulation Act which is more specific. But let's say not every time you will have specific laws. Then bacha, you will be following that law which has come later in time. Now what is this later in time? For example, you have studied Indian Contract Act 1872 wagering, yeah? So lotteries is wagering and hence void, that's what you have studied. But Income Tax Act 1961 says lotteries are taxable at a flat rate of 30% and they are obviously valid. So here bacha, 1872 Act says it's void, 1961 Act says it's valid. So in practical life bacha, we give preference to Income Tax Act 1961 because it has come later in time. So why do we take later in time? Because that's more updated. Exceptional construction is very simple. And means both, or means either of them. Normally may, when I use the term you may do this, means it's optional. That means it will have a directory force. But there will be some cases where may will be treated as shall. That means it will have a mandatory force. And here the shall or must words will mean mandatory. You shall do this, you must do this, it is compulsory. But sometimes even shall or must will have a optional force, that is directory. So how will you judge whether it is mandatory or directory? I'll tell you example. You're using a lot of negative words. No person will do this, no person shall do this. Then it is appearing that it is mandatory. Or if you don't do this, you will have to pay penalty, then it is obviously mandatory. Or you are suppressing the mischief or suppressing some fraud. So you have made some law to stop mischief or stop fraud, then it is definitely gonna be mandatory. Then bacha, if it is coupled with duty, means if it's your duty na bacha, you have to do this. There is no choice. It's your duty to do this. So it is mandatory. But where bacha public policy is not involved or public is not involved, it's not against the public, it's just a procedure, then it's optional. That means it's gonna be directory. See, section 3 of Companies Act says company may be formed for lawful purpose. You don't have a choice. You have to form the company for lawful purpose only. So here the may word will be treated as shall and so on. So these 5 points also they have asked in exam, so important from exam point of view. So that was your exceptional construction. Adjusdem generis is very simple. It means of the same class or species. So milk, ghee, paneer, etc. What will be included in etc? Land building? No. Etc. will include the milk products or the dairy products, right? So in this case that is adjusdem generis. But there should be multiple words. That means you can't just write milk, comma, etc. So the person will not come to know what will come in etc. So there should be multiple words. The words should be of the same class. You can't write milk, comma, lion, comma, rose, comma, land, comma, mines, etc. What are you trying to say, boss? So it should be of the same class or same species. And it should not exhaust the whole category. You wrote everything and then you wrote etc. It doesn't make any sense. So adjusdem generis means etc. Okay. Now coming to secondary rules. Express genuineus est exclusio ulterius. Express mention of one thing while silently excluding other things. Now those who did not understand. Suppose if I say, I'm assuming there is a physical face-to-face class here, and if I say, "Hey class," everyone looks at me terrified. They are like, what happened to her now? Then I say last bench. They all are like, okay, we are saved. Black t-shirt last bench. The moment I say black t-shirt, bacha, I have silently excluded others. So expressing one while silently excluding others. Okay. So if I tell my aunt that I am coming to your house with my husband, me and my husband are coming, full stop, it's so easy. Yes, it implies that other family members are not coming, my son is not coming, my mom is not coming, my mother-in-law is not coming, and so on. So in this particular case, express mention of one thing while silently excluding others. Simple. Nociteres sources means associated words. The word plant means trees. The word plant also means machine. So in this case, bacha, in some law, if I write plant and trees, here the word plant will mean trees. In some law, if I write plant and machinery, here the word plant will mean machine. So what is the meaning of the word plant? It depends on its associated word. Associated word means it depends on the next word. So nociteres sources means associated words. And effect of usage, again important from exam point of view. So bacha, what is this effect of usage? They have given you two Latin terms, optima legem interpres as constitute, contemporanea expositio est optima et forcene in lege. No, I am not cursing you, don't worry. So what is this? See, first of all, they are telling you very simple thing. Custom is the best interpreter of law. You find some rules which are very old or redundant. Some rules are very old and they are very redundant, but still they have not amended it. So you just see what people do in practical life and accordingly you interpret the law. For example, in your Indian Contract Act, they have given you communication of offer, communication of acceptance. They were still talking about post and telegram and whatnot. That is very old. Who communicates these days via post and telegram? We communicate through telegram app maybe, but definitely not that old telegram which we had, right? So this is a very old law and they have not amended it. So in practical life, bacha, you will have to see what people do. For example, nowadays, social media is a new thing, as in you can start opening your businesses on social media. There are so many people who have opened their own pages on Instagram. Home bakers are there, then jewelry or boutique, etc., etc. They make those reels, etc., to get popular. So if I like a particular page and if I want to place an order, I will DM that person, that is direct message that person on the Instagram, and there I will ask, is this available, what is the price, do you deliver here, etc., etc. He says yes, it is available, this is for so and so price, and this is available and we deliver it at your pin code also. I said fine, then I want to place an order. That means if you notice, bacha, I gave an offer on Instagram, he accepted it on Instagram, and we made a contract on Instagram. Now obviously all this is not covered in Indian Contract Act, no? So you will have to see some rules which are old. You have to see what people do in practical life. They follow emails, faxes, Instagram, other social media, Facebook, you have Facebook Market, etc. So you have to see what people do. And contemporaneous expose issue, they are just saying one thing, expose the old laws to new circumstances and technology. Again, Indian Contract Act does not cover electronic contracts, e-contracts. But ma'am, we studied it in CA Foundation. Bacha, that you had in your syllabus, but that is not actually there in the act. So in this particular case, electronic contracts are not covered in Indian Contract Act. That does not mean they are void. They are perfectly valid. So you will expose the old laws to new circumstances and technology. See, eventually conclusion, these two, the effect is same. That see what people do in practical life, but the terminology has changed. So I explained you both. These were all your secondary rules. Now coming to your internal aids. First one is very simple, the title of the chapter. Preamble, it tells you the scope and object of the act, that this is what we are going to do and this is the reason why we have made the law. Negotiable Instruments Act has been made to cover rules on 3 negotiable instruments: promissory note, bill of exchange and check. So if you get confused in the law, obviously you will apply the preamble. Then headings and title of each chapter, which we use the term chapter in law, but in syllabus we use the term unit. Now Companies Act has 29 chapters. You had studied sale of goods, some few chapters, etc. So if the chapter's name is performance of contract, so if you get confused in the chapter, that is unit, you will see, oh, it's performance, so this can be interpreted in this way. So that is headings and title will also help you in interpreting the law. So aids of interpretation, bacha, aids means help, internal means you will find this within the law, and here external means you will find it outside the law, right? So I told you title, preamble, headings, and then coming to marginal notes. Marginal notes, so bacha, in your textbook, you have written this in the textbook, and left hand side, in the class I tell you to write this. So this is a marginal note. So basically marginal note is simple interpretation of what you read here. It's basically summarizing the law, right? So it helps you to understand this in a better way. Same thing, even parliamenters, when they make laws, they do make some marginal notes. They summarize the effect of this section. So marginal notes also can be referred to interpret the law. But bacha, in headings and marginal notes, both, there is a controversy. Some courts say that it should be considered, Some courts say that it should not be considered for interpretation. Yes, so ma'am, what are we supposed to do? To be honest, write both. Theory question, you have to write both. Then next, definitional clauses, two main types of definitions. As everyone knows, section 2 is definitions, or maybe some act section 3 is definition. For example, in general clauses act section 3 is the definition. So anything. So bacha, definitions there are of two types. First you have exhaustive and second you have inclusive. So this means this, it's exhaustive. Company means a company incorporated under Companies Act 2013 or any other previous Companies Act. So this means this, full stop. It has exhausted the category. It is known as exhaustive definition. But debenture includes debenture stock, bonds or any other thing evidencing a debt, whether constituting a charge or not. So what did I say? Debenture includes this, this, this. It is an inclusive definition. Just tell me, bacha, whether it is inclusive or exhaustive. Okay, example. You have done the definition of share in Companies Act. Share means a share of share capital of the company and it includes stock. So this means and includes. So the both words are there, means and includes. So bacha, which type of definition is it? Exhaustive. They have clarified here. Exhaustive, it will mean something or mean and include something. Inclusive, includes something, deems to include, apply and include. If you see these words, it is an inclusive definition. Illustrations, they are examples. So if you see, they also know that it is very, very difficult. It's confusing. So they give you examples. See, illustrations. So illustrations help you to interpret the law. Yes, very important from exam point of view, proviso. Students mix up proviso, saving clause and exceptions. So what is proviso? Some students tell me, ma'am, proviso is provision. Okay, does that mean ION is gone? They forgot. But your proviso means it is qualifying something. You say, na, so and so, so and so, so and so provided this. So that provided which you write is known as a proviso. Provided. In our language, bacha, we write however. But they write in law provided. So I'll tell you, I'll show you the proviso. See, this is Companies Act, Bare Act. You will find this definition small company. 2 clause 85, right? Small company means so and so, so and so, so and so. And see, they have given you provided. Nothing will apply to this. So by writing this, they have put a condition that this is not going to apply. This is not going to apply to these companies. So proviso does the work of putting a condition. See, here also subsidiary company provided so and so. So wherever you write provided, it is always going to be condition. So normal function of proviso is to accept something or to qualify something, that is put a condition. So what is the difference between an exception and a proviso? But your exception is for the whole section. I'll show you. Indian Contract Act, they will write exception. See, exception. If you remember, you had done agreements in restraint of legal proceeding is void. Exception 1 this, exception 2 this. This is not your notes, huh, bacha. This is the Bare Act which I have downloaded. You will find it anywhere. So exception is for the whole section, proviso is for that particular point. So exception is intended to restrain the enacting clause. Matlab, this clause is not applicable to this, that's it. Proviso is to remove those special cases. And saving clause is used to preserve your destruction against certain rights. Now what is this? Example. Example, let's say A and B contract where A is going to sell goods and B is going to pay 1 lakh. But they made this contract under Sale of Goods Act, Indian Contract Act. Yes. Now what if I tell you these acts are repealed? Repealed means cancelled, gone. So poor A and poor B, they can't sue each other. So if these acts go, can I say A and B's rights will also go? No, na? Their rights, they will still get the rights? Yeah. So they have saved them. So what Parliament does is, they will put something known as saving clause. I'll show you. So saving clause will say that even if the act gets repealed, it will not affect the rights of the parties. See, saving clause. Nothing will affect the rights. So even if this act goes, it will not affect A and B. A and B can still sue each other. After this act, if new contract is made, they will not get rules as per this. They will not get the rights as per this. But otherwise, you have saved from any destruction. So exception, that this section is not applicable to these cases. Proviso means they are removing some cases, and saving clause means they are saving you from destruction of rights. Then bacha, explanation. Explanation is nothing but simple words clarification. So this section includes this but excludes this. Yes, this is what we are trying to tell you. This is the meaning of the section, and so on. So they will insert explanations in between. So bacha, here also you will find a lot of explanation. See, explanation. They'll keep inserting like this. So obviously you will use explanation for understanding this particular law. So explanation. Next, schedules. I don't even have to tell you. Schedules in Companies Act, you have Schedule 1, Schedule 2, Schedule 3 and so on. So if you ever get confused in the act, you can also apply the schedules in understanding the law. Read the law as a whole. Obviously, don't read it half and then try to interpret it and then get confused. You read it as a whole. Historical settings. Sometimes if you get confused in what is law trying to tell you, you see the background, why the law was made. Yes, and in this case accordingly interpreted. For example, Child Marriage Act was made because they wanted to stop children from getting married. Because what used to happen is small girls used to get married, and the moment they attained puberty at the age of 12, 13, they used to get pregnant. And their body is not that strong to conceive a baby and deliver a baby. So many girls used to die, and the baby also used to die. So government is like, no, we will not encourage this, so at least they made Child Marriage Act. So bacha, you will see the background why the law was made. Then consolidating statutes and previous laws. Example, General Clauses Act was made in 1897. But before that it was made in 1868, it was also made in 1887, and it was also made in 1897. So bacha, if you read General Clauses Act 1897, so now the question is whether only rules of 1897 Act is applicable or all the rules. So they will write that this act consolidates General Clauses Act 1868, then General Clauses Act 1897 and General Clauses Act 1887. So all three they have put. So this line indicates that okay, all rules are applied, all rules are consolidated together. Then usage, that is what we do in practical life. So what is reasonable time is not given in Indian Contract Act. You will apply what people do in practical life. So reasonable time will depend on facts and circumstances of each case, right? For perishable goods it can be 1-2 days. For furniture it can be 1-2 weeks and so on. So you will see the practical life usage. Then earlier, later and analogous acts. Sometimes bacha, you have one law made in a different century, another law made in another century. But if their object is similar, you will be reading them at the same time together. For example, Indian Penal Code was made in 1860. The object is to suppress crimes. Then Information Technology Act was made in 2000. The object was to suppress cyber crimes. But you will read both the laws together because their particular object is similar. Even though they are made in two different eras, still you will read them together. Then dictionary definitions. You will apply dictionary if nothing else works out. First you give the preference to your own act definitions, not there. You follow general clauses act definitions, not there, then dictionary as a last resort. But if you have multiple meanings, you choose the most appropriate meaning given in the dictionary. And lastly, bacha, you can apply foreign case laws as well. Foreign case laws, but not of any country. Only that country which has similar jurisprudence, means similar judicial system like of India. For example, India and UK, they have similar judicial system. So you can follow UK case laws. But you can't follow American case laws or Canadian case laws or African case laws because they are very different. Their judicial system is different. But first you give preference to Indian law, you are confused, then you give preference to Indian case laws, you're still confused, then you can give preference to foreign case laws. So that is your sixth one. So what we saw was interpretation of law, that is interpretation of statutes. But now a very small thing, bacha, they can ask you this for 4 marks or 5 marks. What are the rules for interpretation of deeds and documents? So if let's say you are a practicing chartered accountant and if a client comes to you that this is a partnership deed, just see and tell me now whether it is proper or not. You can't say out of syllabus. So you need to know how to interpret a document. First point, they are just saying read everything literally in a very simple way. You consider the background of the parties, you consider the intention of the parties, you also consider the surrounding circumstances. After that, you give meaning to each word, and very important bacha, the same word will have the same meaning throughout unless you specifically mention something else. And the status and training of the parties is to be considered. See, for example, if a normal person is making this deed or document, he will write some word in a different context. But if a legal expert writes that document, he will write that word in a very different context. For example, property. Property means, in practical life of people, property means asset. So if a normal human being has drafted that document, if he writes property, it might mean asset. But let's say if a legal expert is drafting it, property means ownership in a way, right? You have done this in Sale of Goods Act. So whenever he writes property, here the meaning will be ownership and not asset. So you'll have to see that. Plus, if there is any contradiction between two parts of the same document or two clauses of the same document, you have to give preference to that law which has come earlier in time. But in case of your harmonious construction, you used to give preference to that law which has come later in time. But when it comes to document, you have to give preference to that part which has come earlier in time. So this was your interpretation of deeds and documents. Now a very small thing which I want to tell you, that is document. What exactly do you mean by document? It is nothing but a paper or any material which gives you information and it can be used as evidence. But law does not like anything which is so simple. So what is this? Document means any matter expressed or described on any substance by means of letters, etc., for the purpose of recording that matter. Now if you read like this, it will go bouncer. I will just tell you in a very simple way. Bacha, documents, there are 4 components. First you have matter, second you have substance, third you have record, and fourth you have means. Matter is what you write, substance is on which you write, record is by which you write, and means is how you write. You wrote ABCD words, etc. This is the matter which you have written on paper. Paper is the substance. You wrote it by pen. The pen is the record. Means how you wrote it. You put symbols, you put alphabets, you put numbers, alphabets, digits, etc. whatever. So matter is what you write, substance is on which you write, record means by which you write, and means is how you write. So now you will understand the definition. matter expressed or described on any substance by means of letters, figures, marks, etc., or multiple means for the purpose of recording that matter, that is pen. So this is your document. I hope you are very clear, bacha. I would still stick by my words. Please do writing practice of at least those 4-5 questions which I have told you. It's important. Please keep writing Latin terms. It will improve your spellings and it is definitely gonna boost your confidence. Don't worry. Yes, you will be able to write, but just ensure whatever I have told you, you follow. Okay? All the very best, bacha. Bye-bye.